mundo y bienvenido a mi canal. Yo me llamo Sirey. Soy una abogada afro-latina licenciada practicando la ley criminal, pero como todos ustedes, a mí me fascina cuando estamos hablando de casos de crímenes reales. En este video vamos a hablar de Mackenzie Shirilla. Si quieren más video en español, nomás dime allá abajo. Hi everyone and welcome back to my channel. My name is Desiree. I'm a licensed and practicing Afro-Latina criminal attorney who, much like the rest of you, has a severe fascination with true crime cases. Listen. Okay, you guys. So I think with the recent media coverage on this case, but more specifically, there was a documentary on Netflix called Crash. And this case, unfortunately, has resurfaced. I say unfortunately only because I'm thinking about the victims' family members and the closure that they should have gotten a long time ago, but for this case now renewing itself. Okay. Long story short, it's my understanding that on April 27th of 2026, Mackenzie Shirilla, by way of her attorneys, files an appeal with the Supreme Court of the state of Ohio. Guess who got her hands on that appeal? And guess who's going to go through it together? You and me. On July 31st of 2022, Mackenzie was driving with her then boyfriend Dominic Russo and their friend Davion Flanagan when all of a sudden she caused a collision while she was driving at an excessive speed that claimed both of their lives and injured herself. I actually don't remember what video I told you guys about this in. Actually, wait. Yes, I do. It's the Corey Richin sentencing video. So do you remember how Corey back in Utah, she was given two options, right? Life with or without parole. And do you remember how I said different states will phrase it differently, right? So meaning life without the possibility of parole or 25 years to life in Corey's case in Utah. Okay. So here in Ohio, after she was convicted of the murders of both Dominic and Davion, Mackenzie was sentenced to 15 years to life, concurrently, two separate sentences as to each victim. Now let's stop right here and tell you what that means, just a little bit. So basically it's life with the possibility of parole after 15 years. That's basically what it is, right? Now, we talked about consecutive versus concurrent sentencing, but just a brief reminder for all of you guys who might be interested, it just means that instead of stacking the life sentences or the 15-year to life sentences, the court was lenient, quite frankly, and gave her the opportunity for both of the sentences to run together and merge. So she's only doing one sentence of 15 years to life versus two. Does that make sense? It's also my understanding that after her convictions, she appealed to the Ohio Court of Appeals, but I guess the appeal was filed untimely. More specifically, that appeal was filed 1 day late. After the court rejected the appeal because of the untimeliness of the motion, Mackenzie and her attorneys filed a brief with the Supreme Court of the state of Ohio. Are we all caught up now? Let's go ahead and get into what that motion says. As you guys can see here, at the top it says Supreme Court of Ohio, Clerk of Court, filed April 27th, 2026, case number 2026-0519. In the Supreme Court of Ohio, State of Ohio is the plaintiff and appellee. Mackenzie Shirilla is the defendant and the appellant. Defendant appellant's memorandum in support of jurisdiction. The summary says the following. Mackenzie Shirilla, who was 17 years old when the car she was driving crashed into a wall at a speed in excess of 80 miles per hour, is serving a life sentence for murdering her two passengers. There is medical evidence that Mackenzie Shirilla suffered from a pre-existing medical condition that could have caused her to black out while driving. But that evidence was only cursorily referenced at trial because defense counsel, despite being aware of Ms. Shirilla's condition, did not adequately investigate this aspect of the case and did not attempt to secure expert testimony. The only post-conviction avenue for bringing trial counsel's ineffectiveness to light is a petition for post-conviction relief under RC 2953.21. Mackenzie Shirilla's petition for post-conviction relief was, according to the trial court, filed out of time. In the instant case, the 8th District Court of Appeals affirmed the trial court's dismissal. In so doing, the 8th District incorrectly determined the deadline by which a post-conviction relief petition needed to be filed. And the result of that error is that Mackenzie Shirilla could die in prison. The 8th District's error in upholding the dismissal of the petition for post-conviction relief is a result of ambiguity in the post-conviction relief statute. The ambiguity centers around the meaning of the term trial transcript, which is used to measure the time by which a post-conviction relief petition must be filed, i.e., 365 days after the filing of the trial transcript. That ambiguity has been a source of contention for district courts of appeals throughout the state, which is why what has happened in this case is symptomatic of a much larger issue that needs the plenary consideration of this court. Okay, you guys, before we get into anything more, let me just give you guys my opinions on the summary as stated by Mackenzie's appellant attorneys. So basically what I gather is this. Basically, what they're saying is that they're blaming the trial attorney for not bringing up evidence of Mackenzie's alleged medical condition into the trial, right? What they're saying is that the trial attorney was aware of this medical condition, but didn't hire any expert witnesses by which to testify about this condition. And should they have done that, should the trial attorneys have done that, she might not be sitting in prison, allegedly, according to them. I think that argument is fallacious. I think it's silly. I think it's ridiculous. I think it's salacious, and I don't like it. And I will explain to you why. Despite the fact that every criminal defendant is entitled to counsel, one, they are not entitled to the counsel of their choice. Meaning, if the defendant is indigent and a public defender or a state-appointed attorney is assigned to that person's case, you don't get to choose which public defender you want. You get a state-appointed attorney. Period. Right? So let me just be clear with that. I don't know if there was a public defender defending her on this case. I think there might have been, but that's not of any moment because I'm not dissing the public defender. Okay? What I'm saying is this. Likewise, like you don't get to choose what type of counsel you want, you also don't get to choose the trial strategy. Okay? That is just very clear. That's well established. You don't get to choose your own trial strategy, right? So even if Mackenzie mentioned this alleged medical condition to her trial attorney, and the trial attorney was aware of it, it is still the trial attorney's decision, quite frankly, whether or not he or she chooses to put on experts as it relates to this medical condition. In my opinion, just because the attorney chose not to put on expert testimony as it relates to this alleged medical condition does not mean that that attorney was ineffective. I'm just going to be very clear. Okay. So I didn't like that they said that. I also didn't like the dramatization of all of this. Okay. Claiming that the Court of Appeals inaccurately calculated the dates. This is a statewide issue that needs to be addressed. And even more so, you know what else they said? Oh, because of this, Mackenzie could die in prison. Not because of her actions, not because of her actions, but because of this. Yeah. Let's carry on. Ohio's 2 avenues to prevent wrongful convictions. When a criminal defendant is convicted of a felony in a court of common pleas, the defendant has 2 principal options for redress. The defendant's first option for redress is direct appeal. The defendant appellant is ultimately responsible for amassing the record below to include the transcription of any in-court proceedings relevant to the case, whether it be a transcript from a Bindover hearing, a transcript from a suppression hearing, a partial or complete transcript of the proceedings during trial, and/or a transcript of the sentencing hearing. Of course, not all cases include a Bindover hearing or a suppression motion or a trial, but as this court is well aware, the transcripts from in-court proceedings relevant to the appeal must be prepared and made part of the file. Why? Because the appeal in a criminal case is a review of what took place on the record in the proceedings that led to a conviction. I'm going to stop right here before I get into anything further. I think out of all the motions that we've reviewed of different attorneys that are writing, I dislike this writing style the most, okay? Because I don't think I would ever, I'm sorry, you guys, I would ever say to a court, why, question mark. That's just crazy to me. There are more articulate ways to say that to a court, especially the Supreme Court of the state in which you practice. The reason being for that, The explanation serves this. The rationale behind that logic is such. You just gonna say why? Question mark. This is not a text message, sir and or ma'am. That's just tacky. I didn't like that. I didn't like that at all, but let's go ahead and carry on. The second option for redress is a petition for post-conviction relief filed pursuant to RC 2953.21, whereas the direct appeal only examines the record that was developed that led to the defendant's conviction. The post-conviction relief petition looks outside the record to see if a defendant's constitutional rights were violated. For example, if defense counsel failed to adequately investigate the case, that omission might not be apparent from the on-the-record proceedings that led to the conviction, but could come to light via affidavits and subsequent testimony at a post-conviction relief petition. And this court has made it clear that RC 2953.21 applies to a defendant who has either been tried and found guilty or who has pled guilty and has been convicted. Calhoun recognized that the statute was the statutory vehicle by which Ohio meets its 14th Amendment due process obligation to provide an efficacious remedy for defendants who claim that their own convictions were secured in violation of federal constitutional rights. Hold on, you guys. You see this phone right here? I'm looking something up real quick. Okay, efficacious is a word. What it means to be efficacious. Efficacious means producing the intended result or having the power to achieve a desired result. All right, I'm just making sure. Okay, because he already addressed the court or she already addressed the court using why. So I just want to make sure because I ain't never heard of that word. Have you heard of that word? Have you heard of that word? Anyways, let's carry on. The result is that the General Assembly has designed a remedial structure that ensures a review of 1. What happened on the record leading up to the conviction, i.e., a direct appeal, and 2. What did or did not happen off the record that contributed to the conviction. When must a post-conviction relief petition be filed? The instant case is about determining the deadline for filing a petition for post-conviction relief. The General Assembly recognizes that appeals will normally go first and further recognizes that what took place on the record leading to the conviction is always needed to establish if a post-conviction relief petition is truly addressing matters that did not take place on the record. Competent post-conviction counsel must understand the trial court's record before deciding what issues, if any, can be raised in a post-conviction relief petition. Understanding the record means being familiar with the court proceedings that led to conviction, usually by reading the pertinent transcripts. For that reason, the deadline for filing a post-conviction relief petition is measured by the number of days after the trial transcript was filed in the direct appeal. Where no appeal is taken, the deadline for filing a post-conviction relief petition is measured by when the appeal deadline expired. Until March 23rd of 2015, the deadline was 180 days after these events. Now it is 365 days after these events. Recognizing that it is the entire record leading to the conviction that creates the starting point for any post-conviction relief petition, why would the statute use the filing of the trial transcript as the pivotal event for stating the post-conviction relief petition filing deadline? What happens if the post-conviction relief petition is challenging counsel's failure to call a key witness at a suppression hearing where the losing defendant then pled no contest to preserve the suppression hearing on appeal? The only transcript filed in the appeal would be the transcript from the suppression hearing. Would the lack of a trial transcript mean no ability to pursue a post-conviction relief petition despite counsel's omission? Or would the fact that an appeal was taken but a trial transcript had yet to be filed because there was none mean that the defendant has no time constraint on filing a post-conviction relief petition because 20 years later the trial transcript still has not been filed? Either option is absurd, and there is no presumption that the General Assembly does not intend absurdity. I'm going to stop right here again. I've told you guys in some of the other cases that we talked about different motions that were filed by attorneys. I don't necessarily enjoy the fact that attorneys like to whine a lot because to me, this is just like politically correct whining a little bit. It's absurd. This is preposterous. How dare they? That wasn't the intent. And it's just like, sir and or ma'am, just make your point, please. Because I'm sure that, I don't know, it's not winning any favors with any judicial body ever. Okay? It's just really sad. And I don't necessarily care for it, and I don't enjoy it, and I don't like it. I think I'm not going to say that I've never gotten like sassy in emotion because I do that all the time. But I don't think whining really helps your position at all. I think it makes you look weak. I think it makes you look cowardly. And I think, I don't know, it's not really doing Mackenzie any favors. Okay, let's carry on. Suppression issues present just one type of appellate scenario where there is no trial transcript. Defendants have the ability to preserve a myriad of issues for appeal without going to trial by entering no contest pleas, including motions to dismiss because the statute is unconstitutional and motions to dismiss for pre-indictment delay. Other cases that have gone to trial might proceed on appeal without the trial transcript because the only issues raised on appeal were fully litigated either before trial or at sentencing. The point is that a trial transcript is not always essential to or included within the record on direct appeal. Yet, post-conviction relief may still be appropriate in those cases. Which again raises the same question previously asked. So what did the General Assembly mean by the term trial transcript? District courts of appeals have grappled with this question. In State v. Barker, the first district addressed the issue in a case whose judgment is contrary to the judgment of the 8th district in the instant case. In Barker, the defendant made a motion to suppress that was denied, after which he pled no contest to preserve the suppression issue on direct appeal. The defendant ordered a complete transcript of the proceedings. This included the transcript from the juvenile court, Bindover, the suppression hearing, the no contest plea, and sentencing. The first district noted that Baker was convicted upon no contest pleas, and thus there was no trial transcript to be filed. While most of the transcripts were prepared and filed earlier, the suppression motion transcript was filed more than 1 year after the transcript of the plea and sentencing and 10 months after the transcript of the Bindover hearing. Thus, the post-conviction relief that was filed would only be timely if its filings were measured in relation to the filing of the suppression hearing transcript. Barker examined the issue and determined that the term trial transcript had to be interpreted to mean those transcripts necessary for inclusion in the record on appeal. In reaching this decision, Barker noted that this court in State v. Everett had used the terms trial transcript and transcripts of proceedings interchangeably. Barker also noted that because the suppression hearing transcript was utilized in the direct appeal, there was no concern that the defendant had used a late filing of the transcript as a means of extending the post-conviction petition filing deadline. In this regard, Barker recognized that the defendant had ordered the complete transcript at the time the appeal was initiated. Barker makes sense. Trial transcript cannot be taken literal without violating Calhoun's interpretation of the statute as being efficacious in cases where there was no trial, and by requiring that the transcript of the proceedings below be necessary to the direct appeal, gamesmanship is avoided. In State v. Porter, the 7th District addressed the filing deadline for a post-conviction petition in a case where the sentencing transcript was filed after the trial transcript, employing the test articulated in Deaton. The 7th District held that the sentencing transcript was objectively necessary for the appeal, and thus its filing began the 365-day time limit. The Court of Appeals are not unanimous with respect to this issue. The 10th District Court in State v. Neal held the filing of a suppression hearing transcript after the transcript of the trial had already been filed did not extend the 365-day deadline to file a post-conviction relief petition. In the instant case, the 8th District resolved the issue consistently with the approach taken by the 10th and 11th Districts, as discussed in more detail in the statement of the case and facts below. When Mackenzie Shirilla took her direct appeal on September 11, 2023, her appellate attorney immediately ordered a complete transcript of the proceedings and identified in the precipice and docketing statement that a probable issue on appeal would center on the juvenile Bindover. The transcript of the proceedings in the Common Pleas Court General Division was filed on October 24, 2023. However, the juvenile transcript was not filed at that time. Instead, successor counsel, who noted his appearance on October 23, 2023, was required to contact court staff in the juvenile division to secure the transcript, despite its having been identified as necessary from the initiation of the appeal. The juvenile transcript was cited repeatedly by the defense in in the merit brief's first assignment of error on direct appeal. The prosecution's brief of appellee similarly cited the juvenile transcript, and the ensuing decision in the original appeal discussed the evidence presented at the Bindover hearing. Mackenzie Shirilla's petition for post-conviction relief was filed on October 24th of 2024, within 365 days of the filing of the transcript of the juvenile Bindover, but more than 365 days, 366 days to be exact, after the filing of the transcript on October 24th, 2023. The trial court dismissed the petition for want of jurisdiction because it had been filed more than 365 days after the filing of the transcript of the proceedings at trial in the direct appeal. The 8th District affirmed the dismissal, holding that the transcript of the juvenile Bindover proceedings could not constitute part of the trial transcript for purposes of the statute. The 8th District distinguished Barker on the basis that Barker involved a no contest plea and not a trial. The above recitation indicates that there is a division among the District Court of Appeals on what constitutes the trial transcript for purposes of the statute. In the instant case, the 8th District denied a defense motion to certify a conflict between its decision and Barker. The 8th District offered no explanation for denying the motion to certify conflict and entered its order denying the motion just one day after prosecution's opposition to the motion was filed, without providing the defense with the 7 days to reply under Appellate Rule 25B. Whether viewed as a conflict or not, the division between the District Courts of Appeal is nonetheless stark. This court is asked to accept the following proposition of law for plenary consideration. For purposes of RC 2953.21A2A, the trial transcript is the transcription of those proceedings whose transcription was objectively necessary for inclusion in the appellate record on the direct appeal, but does not include transcription of those proceedings whose inclusion in the record on appeal was not necessary and was employed as a means of artificially extending the deadline to file a petition for post-conviction relief. Ms. Shirilla was charged in the Cuyahoga County Court of Common Pleas Juvenile Division by way of a complaint with aggravated murder, felonious assault, aggravated vehicular homicide, drug possession, and possession of criminal tools. On March 2nd, 2023, the matter proceeded to a Bindover hearing pursuant to Juvenile Rule 30. At the conclusion of the proceedings, the court found that the state failed to establish probable cause to support the aggravated murder charges. However, the court bound over all other offenses to the Cuyahoga County Court of Common Pleas General Division. Let's go ahead and just stop right there, okay? I don't know if we've really talked about Bindover hearings more specifically, because I don't think we've talked too much about juvenile defendants or defendants who committed crimes when they're juveniles and are now adults, right? But basically, a Bindover hearing is essentially what it sounds like, right? If someone is under the age of majority at the time that they are charged with commission of a crime, it's usually going to be charged in juvenile court, right? That does not limit the prosecution from asking the court to bind it on up to district court, district land where the adults are, okay? And it looks like that's what happened here. What the attorney in this case is saying, however, is that the court did not find ample probable cause as to one of the charges, but bound all the other ones up. Okay, does that make sense? Let's go ahead and carry on. On May 24th, 2022, a Cuyahoga County grand jury returned a 12-count indictment against Ms. Shirilla, alleging 4 counts of murder, 2 counts of felonious assault, 2 counts of aggravated vehicular homicide, 1 count of drug possession, and 1 count of possession of criminal tools. The case proceeded to a bench trial on August 7th, 2023. The trial court found Ms. Shirilla guilty of all charges. After merging allied offenses, the court imposed an aggregate sentence of 15 years to life imprisonment, which reflected 2 concurrent terms of 15 years to life for violations of murder, to wit, the purposeful killing of another, and concurrent terms of 7 months each for drug possession in violation of these 2 statutes, respectively. The case was appealed in the 8th District Court, case number CA 23-113167. The timely notice of appeal filed by assigned counsel on September 11, 2023, contained within its 4 corners a direction to the clerk to transmit the complete record to the 8th District Court of Appeals, which shall include all records and transcripts from the companion Bindover matters before the Cuyahoga County Court of Common Pleas, Juvenile Court Division. Appellate counsel also filed a precipe and docketing statement requesting the complete transcript under Appellate Rule 9B. On that same document, appellate counsel noted that a probable appellate issue would be juvenile bindover issues. The transcript of the proceedings that took place in the General Division was filed on October 24th, 2023, one day after appointed counsel withdrew from the case and retained counsel noted an appearance. The requested transcript of the bindover hearing held in the Juvenile Division was not filed at that time. Retained counsel inquired about the omitted bindover hearing transcript and arraigned for the bindover transcript to be filed. The bindover transcript was filed on December 15, 2023. No objection was raised about the bindover transcript having been filed at that later date. In Ms. Shirilla's merit brief on direct appeal, the first issue raised regarded errors in the bindover proceeding. The juvenile court erred when it concluded that the state presented sufficient credible evidence to demonstrate probable cause to believe that Shirilla purposely and or knowingly caused the deaths of the two victims. The bindover transcript was cited multiple times in the appellant's brief. It was also cited multiple times in the prosecution's ensuing brief of appellee. The issue presented regarding the bindover proceedings included a recitation of the evidence presented at the bindover hearing, was addressed by the 8th District in its decision affirming the convictions. This court declined to hear Ms. Shirilla's appeal in Shirilla 1. On October 24th, 2024, Ms. Shirilla, through the same retained counsel who had been representing her on direct appeal, filed a petition for post-conviction relief pursuant to RC 2953.21. The petition alleged that despite being put on notice by Ms. Shirilla and her family of Mackenzie's condition, trial counsel had inadequately investigated and presented evidence that Ms. Shirilla suffered from a medical condition, which caused her to be susceptible to blackouts, which constituted an exculpatory explanation for her failing to control her vehicle. The state responded to the petition in part by arguing that the petition was not timely reviewed because it was filed 366 days after the trial transcript was filed. With leave of the court, an amended petition was filed. The state again included the argument that the petition was untimely. Neither party moved for summary judgment. The trial court dismissed the petition solely on the basis that it was filed untimely. Ms. Shirilla appealed to the 8th District, arguing that the petition was timely filed because it was filed less than 365 days after the bindover transcript was filed in the direct appeal. 2, the petition was timely filed because it was filed within 1 year of the filing of the transcript of the evidence presented at trial, and the presence of a leap day in 2024 should not disturb this conclusion. And 3, principles of equitable tolling should be applied to excuse any late filing. The state responded in part by arguing that the defense had forfeited any arguments that the petition was untimely because the defense never argued timeliness in the trial court in response to the state's argument in this regard when the petition was pending. But the state's argument in this regard never addressed how or when the defense could have made such an argument, since the statute does not contemplate any plating by a criminal defendant other than the initial petition, an amended petition, and a motion for summary judgment. Moreover, the trial court dismissed the petition without hearing argument or otherwise inviting the defense to address the issue of timeliness. For its part, the 8th District assumed without deciding that the timeliness issue was not forfeited. Nonetheless, as discussed earlier in this memorandum, the 8th District affirmed the decision of the trial court, dismissing the petition as untimely. Okay, you guys, let me stop right here before I get into any further argument that's made by the appellate attorney, just so I can explain a few things to you, okay? So basically, they're arguing over the timeliness of the transcript being filed in the subsequent motion that followed, right? So according to them and according to this specific rule, okay, the motion for appeal needed to have been filed within 365 days after the filing of any transcript, right? And according to the trial court, the motion was filed 366 days afterwards. So basically what they're asking the Supreme Court to do is side with them that their motion was not untimely filed, right? And because it was not untimely filed, then going back down to the Court of Appeals for the Court of Appeals to determine whether or not she's entitled to a new trial based on the motion that was previously filed. Does that make sense? Man, that's a lot. That is a lot going on here. But let's go ahead and continue into the argument that they're making. For purposes of the statute, the trial transcript is the transcription of those proceedings whose transcript was objectively necessary for inclusion in the appellate record on direct appeal, but does not include the transcription of those proceedings whose inclusion in the record on appeal was not necessary and was employed as a means of artificially extending the deadline to file a petition for post-conviction relief. A transcript of juvenile bindover proceedings leading to the defendant defendant's adult conviction is objectively necessary for the inclusion in the appellate record when the brief on direct appeal assigns as error matters that occurred during the Bindover hearing. This court should adopt the first two propositions because the trial court and the 8th District have each denied Ms. Shirilla her 6th Amendment right to effective assistance of counsel and her 4th Amendment due process right to an effective remedy for the violation of constitutional rights. Let me just stop right here and explain a little bit more about my frustration with this brief. I've noticed typically in criminal cases, when defendants don't really have much of a leg to stand on, they'll argue constitutional limitations or constitutional restrictions or whatever, right? So you made these two propositions, and after these two propositions, what you're saying is, well, it violated her constitutional rights. Okay, great. Now let's talk about the timeliness or not the timeliness and why it wasn't filed timely, and just explain that more instead of just falling back on the proposition that this is a constitutional violation. Does that make sense? Whatever, let's carry on into what else they say. The first proposition is derived from the 2nd District's decision in Deaton, which in turn relied upon the 1st District's decision in Barker. The first proposition is also consistent with the 7th District's decision in Porter, a decision based on Deaton and thus part of the Barker progeny. As discussed above, Barker and its progeny provide a logical interpretation of the term trial transcript that ensures the efficacy of the statute, but still ensures that the defendant will not use frivolous transcription filings to manipulate the post-conviction relief petition deadlines. Moreover, Baker and its progeny reach an interpretation of trial transcript that is consistent with the statute's requirement that the procedural matters be interpreted to ensure fairness and justice. The second proposition addresses as a general matter the specific circumstances presented in the instant case. The second proposition complements the first proposition and provides an explanation for what it means to be necessary for inclusion in the appellate record. It is fairly obvious that a transcript of the evidence at a contested Bindover, which is also subject of appeal, is necessary for the appeal. The term trials transcript as used in the statute is sufficiently vague and has been sufficiently subjected to varying interpretations that the principles of equitable tolling will excuse a failure to file a timely petition for post-conviction relief, where the petition was filed within 365 days of a transcript that was reasonably included in the record on direct appeal. When a petition for post-conviction relief provides substantial reason to believe that, if granted, the defendant would be acquitted at a new trial, principles of equitable tolling may be exercised to excuse the late filing of a petition for post-conviction relief pursuant to the statute. At the end of the day, the United States Supreme Court in Young v. Rajan and this court in Calhoun have made it clear that the constitutional due process under the 14th Amendment and Article 1, Section 16 of the Ohio Constitution are about ensuring adequate relief for prisoners whose constitutional rights have been violated. Mackenzie Shirilla's rights to effective assistance of counsel under the 6th Amendment has been violated. Moreover, Ms. Shirilla's 6th Amendment right to the effective assistance of counsel is particularly violated, whereas here, the petition for post-conviction relief demonstrates that she would have been acquitted had trial counsel been effective. Accordingly, each of these propositions is grounded in Ms. Shirilla's constitutional rights. Under such circumstances, particularly when there is a claim, as here, that Mackenzie Shirilla was actually innocent, the principle of equitable tolling has a place at the table. Under this principle, a trial court has the ability to do something that neither the trial court nor the 8th District believed was possible in the instant case: excuse what would otherwise be a late filing. There are two reasons for equitable tolling to be applied in the instant case. First, as discussed above, there is a considerable discord about what the term trial transcript means. This has created an excusable ignorance of the deadline, which federal courts have recognized in other contexts is a bias for equitable tolling. To that end, courts give the equitable consideration to the confused state of the law. Second, whereas here, the petition for post-conviction relief demonstrates that Mackenzie Shirilla would have been acquitted had she received the effective assistance of counsel, equitable tolling is necessary to avoid an injustice. Conclusion: wherefore, this court should accept plenary jurisdiction over the instant case. Okay, you guys, that was a lot that we just went through together, but let me just go ahead and give you guys my opinions on it, or some of the opinions I haven't already shared, okay? So first, I noticed that her attorneys on appeal are misspelling her name quite a bit. I see it in different places spelled as S-H-E, if you noticed on the screen when I put it up there, and I think that's really radical, right? Not that mistakes don't happen, not that we're all not busy with numerous people, But like, I think that's just a sloppy error on their part. Second, I wholeheartedly disagree with the argument and the notion that merely because trial counsel did not put on an expert to testify as to Mackenzie's alleged condition, that means that the counsel was ineffective. And further, that means that if counsel would have put on that expert, she would have been acquitted. I don't agree with that at all, right? I think one of the things that I have learned throughout doing trials is that no jury can ever be predicted. No jury is predictable, right? So there's no way to tell which way a jury is going to go. And even if this expert were to have testified, that does not necessarily mean that the jury would have believed the expert and that Mackenzie would have been acquitted. That's not what that means, right? So, it is what it is. I understand the position that this counsel finds itself in, I guess, but, I guess they're just doing what they have to do. And further, you guys, just one last thing. Let me explain to you what equitable tolling means, okay? Basically, it's just a legal doctrine or a legal mechanism by which the court would excuse the late filing. Basically, that's what it is. Basically, that's all they're asking for the court here, because I know they mentioned it quite a few times in their motion. So let me just explain to you what that means. And I did, and that's that. All in all, it would not surprise me if the Supreme Court, said that their motion was timely filed for the Court of Appeals to rule on it. It wouldn't surprise me. Yeah, let's just leave it there. Okay. But do I think that her argument makes sense as a whole, as in the whole ineffective assistance of counsel thing? Not in the slightest. But that is it for this video. Before I let you guys go, like I've told you a million times before, I'm going to keep saying this. If you enjoyed this video, can you please tell me? Can you please tell me what you liked about it? If you didn't enjoy this video, you can keep your hating ass on somewhere. Just kidding. I'm open to constructive criticism. So tell me what you don't like about it, or let me know if you want me to explain something differently, okay? As always, thank you guys so much for watching. Please be sure to like, comment, share, and subscribe. Until next time, y'all take care.